If you've landed on this channel, you've probably already heard the word bankruptcy tossed around a lot. Maybe a little bit more than usual nowadays. But what does it actually mean? And more importantly, what really happens when you file? I'm Jay Harvey, a partner at the Harvey Worry law firm. And today, I'm walking you through exactly what happens, step by step. We'll cover the two main types, Chapter 7 and Chapter 13, the process from start to finish, and the most common mistakes that I see most people make along the way. So, if you're curious about what bankruptcy actually looks like, stick around. But first, a quick disclaimer. This video is for educational purposes only, not legal advice. I'm not your attorney, and bankruptcy laws vary by state and district. Every situation is different, so please consult a qualified local professional about your options. This video is just a starting point. Now let's jump in. There are 6 different types of bankruptcies in the US, but for individuals, only 2 really matter: Chapter 7 and Chapter 13. Chapter 7 is the golden grail of bankruptcies and is often called liquidation or fresh start. It's the most common bankruptcy filed around the US. Essentially, people who file are telling the court, I can't afford to pay these debts. Sometimes this is due to financial hardships or health issues, and other times it is due to personal guarantees on debts. Regardless of your reason, if you qualify, the court will legally erase all of your debt. Now, this almost sounds too good to be true. So here's how it actually works. You may or may not be required to sell some non-exempt assets to pay creditors, but honestly, property being sold in a Chapter 7 is not a normal thing. Most bankruptcy consultations are free, and most attorneys will promptly advise you against a Chapter 7, if liquidation is even slightly a possibility. The whole process completes in about 3 to 4 months. Most unsecured debts, such as credit cards, medical bills, personal loans, etc., are completely wiped out in the process. We call this feature the bankruptcy discharge. Once you file, you should immediately stop making payments to creditors, unless you're planning on keeping something like a car or a house. Otherwise, you are just throwing away money. Now, Chapter 13 is a little bit different. It's a reorganization, or a repayment plan of sorts. You're basically saying, I have income, but I need some time and help restructuring how I pay things. So, the Chapter 13 is used to help you catch everything up. With Chapter 13, you propose a 3 to 5 year repayment plan. During this time, no creditor is allowed to harass or even bother you. You make one monthly payment to a court-appointed trustee who handles paying your creditors each month. So, with this bankruptcy, you do need stable income. It's really an amazing tool if you're behind on a mortgage, facing foreclosure, or if you're about to lose your vehicle. Once you complete the payment plan, whatever unsecured debts remain get discharged. Now, determining which one of these 2 you should file and which one you may qualify for depends on your income, expenses, and assets. Qualifying for Chapter 7 is largely determined by something we call the means test, which is simply a mathematical tool that compares your income against others' income in your county to determine if you have the financial means to pay some or all of your debts. And qualifying for Chapter 13 is largely determined by your ability to feasibly pay your monthly payment timely to the Chapter 13 trustee. Now, that bankruptcy introductions are out of the way. Let's walk you through a Chapter 7 example step by step. We'll follow someone. Let's call him Leroy James. He's got credit card debt, medical bills from an ER visit at Grady, and he was laid off 5 months ago. He's staying at his parents' house, picking up gig work at a local martial arts dojo, and he's behind on everything. So, he plans to file Chapter 7. What are his steps? Step 1, credit counseling. Before Mr. James can file, he has to complete a government-approved credit counseling course. It's about 20 to 30 minutes. It's done online and costs a small fee. At the end of the course, he gets a certificate of completion, which he must file with the court. Step 2, filing the petition. Mr. James works with his attorney to put together a bankruptcy petition, which is basically 40 to 100 pages of forms that lay out his income, expenses, assets, debts, and recent financial history. He also pays a $338 filing fee to the court. Step 3, the automatic stay goes into effect. The moment the case is filed, something called an automatic stay kicks in. Think of it like a legal bubble that immediately shields Mr. James from his creditors. It stops collection calls, halts lawsuits, freezes wage garnishment, and even pauses foreclosures, evictions, or repossessions. Step 4, a trustee is appointed. The court assigns a trustee to oversee the case. They review the bankruptcy petition, look for any assets that could possibly be worth selling, and they ensure the forms are accurate. Step 5, the 341 meeting. About 30 to 45 days after filing, Mr. James attends what's called a 341 meeting. These days, it's usually held via Zoom. The trustee will put him under oath, ask a few questions about his finances, and that's mostly it. Creditors are invited to attend, but they rarely show up. The whole thing is usually done in about 5 to 10 minutes. Step 6, asset review and exemptions. Once again, the trustee looks at what Mr. James owns after the 341 meeting. Since most assets are protected by laws, called exemptions, the trustee files a document with the court explaining that there are no assets worth selling. But if Mr. James did have something non-exempt and worth selling, like a valuable coin collection that he did not disclose, or exempt, the trustee could sell it to pay creditors. Step 7, financial management course. After the 341 meeting, Mr. James completes one more online course called a financial management course. It takes about 30 to 45 minutes to complete. Thereafter, the certificate of completion will be filed with the court. Step 8. The discharge. If everything's in order, the court will issue a discharge order, usually about 60 days after the 341 meeting. That's the official document saying Mr. James no longer owes his dischargeable debts. Case closed. Mr. James is debt-free. All right, now, let's talk about Chapter 13, and we'll follow a new client named Dorothy Gale. Ms. Gale has a car payment, a mortgage, a dog, and a decent job. But last year she had a medical emergency, missed work, and fell behind. Now she's facing foreclosure. Steps 1 through 5 are the same as a Chapter 7 case: credit counseling, filing the petition, the automatic stay, trustee appointment, and the 341 meeting. There are 3 big differences in what comes next. Step 6, Chapter 13, plan. With the petition, Ms. Gale will file a proposed payment plan. This plan will outline her monthly payment and how much of that payment each creditor will receive during her bankruptcy. Step 8, making payments. Starting 30 days after Ms. Gale files, she will start making the monthly payment listed in her proposed plan to her Chapter 13 trustee's office. Step 7, confirmation hearing. Within 60 to 75 days after filing, the court holds a confirmation hearing to review Ms. Gale's repayment plan. Creditors can object, but if the plan is approved, it's locked in. For the next 3 to 5 years, Ms. Gale makes one monthly payment to the trustee, who distributes it to her creditors. She keeps her house, keeps her car, and works her way through the plan. She completes her financial management course, and at the end, Ms. Gale will receive a discharge order from the court. Now, that Chapter 7 and Chapter 13 are a little less mysterious, it is important to note that clients can complicate this process. I've seen these same mistakes over and over again. Mistake number 1, transferring assets before filing. If you give away, transfer, or sell assets for less than their worth right before filing, you are not being creative. The trustee can reverse those transfers. Mistake number 2, running up debt right before filing. Buying luxury goods or taking cash advances with no intention of paying them back. That can be considered fraud, which could lead to the debt being deemed non-dischargeable. Mistake number 3, lying on your paperwork. Everything is signed under penalty of perjury, hide assets, and you can be denied your discharge or face criminal charges. Mistake number 4, skipping the required courses. You are required to complete credit counseling before filing and financial management during the case. Miss either one and you don't get your discharge. Mistake number 5, not checking your credit afterwards. Errors happen all the time. Make sure your accounts are reporting $0 after your case is discharged. One more important thing, not everything gets wiped out. Bankruptcy clears most unsecured debts, not all of them. These generally don't go away. Student loans, except in rare hardship cases, child support and alimony, certain tax debts, debts from fraud or willful injury, court fines, and penalties. If you're not sure about a specific debt, ask your attorney, and be honest with them. I really hope this video helped if you're considering bankruptcy. Just know that you're not alone, and you do have options. If this video was useful, please hit that like button and subscribe. It helps us reach more people who need this information. I'm Jay Harvey, and thanks for watching.